My name is Claire Whitmore. I'm 38 years old. And on the morning my older brother sued me over our late parents' trust, he stood up in a packed Denver courtroom and pointed at me like he was identifying a criminal. She's been living off our parents her entire life, he told the jury. Then he accused me of manipulating our father, hiding estate money, and stealing a future he believed belonged to him. I didn't interrupt. I didn't even look at the reporters he'd personally invited. I just watched my attorney carry a sealed, olive drab envelope to the bench, a faded pentagon seal stamped across the flap, 3 signatures crossing the tamper strip. My brother's confidence disappeared before it was even opened. The judge read the first page, stopped, and looked up at the jury box. One juror went pale. He rose to his feet without being asked and said, "Everyone, please stand." The judge ordered him to sit down, cleared the courtroom, and called both legal teams forward. That's when I heard my brother whisper to his attorney, "That file was destroyed." I heard it. So did my lawyer. That was the moment I understood this case had never really been about an inheritance. It was about what our parents discovered before they died, what my brother had done to erase it, and why they trusted me, of all people, to finish what they had already started. Before I tell you what was written on that first page and what happened after I finally walked out of that courtroom for the last time, tell me, what time is it where you are right now? Where are you watching from? And what's the weather like there? Does it match your mood today? I'm always curious how far a story like this one can travel. 18 months before that envelope ever reached a judge's hands, I was standing in my parents' kitchen holding a pharmacy receipt in one hand and an overdue mortgage notice in the other. My mother had just finished another round of treatment. My father's hands had started to shake, and my older brother hadn't visited in 7 weeks. By then, I had already paid the home care agency out of pocket, replaced a broken furnace, and transferred enough money to stop the bank from starting foreclosure proceedings. I never once called any of it a sacrifice. They were my parents. They'd raised my brother and me in that narrow brick house on Larkspur Street, and when their strength finally started to fail, I did what I believed family was supposed to do without being asked twice. My brother's name is Derek Whitmore, and he preferred to describe his absence as handling things from a distance. In practice, that meant firing off authoritative emails, demanding copies of every document that crossed my desk, and showing up exactly when a photograph or a signature might make him look involved. Derek had always had a gift for occupying the center of a room without ever carrying any of its weight. When our father asked him to help organize the mounting medical bills, Derek said his business was entering a critical expansion phase. When our mother needed someone overnight after surgery, he sent flowers with a card signed, "Your devoted son." I slept in a chair beside her hospital bed for 4 straight nights and took client calls from the cafeteria each morning before sunrise. At the time, I worked as an independent compliance consultant. Companies hired me to find discrepancies in their financial records before regulators found them first. The irony would almost be funny now, if it hadn't turned so cruel. I was trained, professionally, to notice altered dates, missing statements, numbers that refused to reconcile, and yet I kept ignoring those exact same warning signs inside my own family because I never wanted suspicion to be the last thing I shared with my parents. My father, Walter Whitmore, had spent most of his career auditing procurement systems for the Department of Defense. Even in retirement, he treated every household receipt like an official government record. He kept labeled binders, duplicate ledgers, and handwritten notes explaining exactly why every major decision had been made the way it was. He'd also created the Whitmore Family Trust, which held the house, several investment accounts, and a controlling interest in a small industrial safety company he'd helped build from nothing. The total value sat just under $5 million, though my parents rarely spoke about the number itself. What they cared about were 3 simple instructions. The house could never be sold while either of them was alive. Their medical care always came first, and neither child was allowed to profit by weakening the other. I believe those instructions were perfectly clear. Derek treated them like obstacles to route around. After our mother passed away, Derek arrived at the house before sunrise with 2 assistants and started boxing up files. He said he was protecting the estate. I found him in our father's office, prying the trust binder out of a locked cabinet. "Why are you doing this?" I asked. He smiled without ever quite meeting my eyes. Dad's confused, Claire. Someone has to act like an adult here. Our father was grieving, physically frail, and sometimes slow to find the right word. But he was not confused. The week before, he'd corrected a six-figure error in one of Derek's own business proposals from memory, without even glancing at a spreadsheet. When I said as much, Derek leaned in close enough that I could smell the coffee on his breath. "You have no husband, no kids, and no real company," he said. "Don't turn taking care of them into a career." I should have recognized that sentence for exactly what it was. Not an insult, but a rehearsal. Months later, after our father died too, Derek used nearly identical language in the formal petition he filed against me. He alleged that I had isolated our parents, manipulated the final trust amendment, reimbursed myself for fabricated caregiving expenses, and concealed more than $580,000. He asked the court to remove me as successor trustee, freeze every trust account, hand full control to him, and award him punitive damages on top of it. Within 48 hours, he'd sent the filing straight to my largest clients. 2 suspended their contracts immediately. 1 terminated mine outright. The trust accounts were frozen. The home care bills I'd personally covered could no longer be reimbursed. A local business reporter ran a piece with the phrase, "estate fraud allegations," sitting right in the headline. Derek didn't just want the trust. He wanted the accusation itself to become my identity before I ever had the chance to answer it. The first person I called was an attorney recommended by a former client. I didn't even use my own name when I first told him the story. I just described it as a situation with my family. He listened for nearly an hour, without interrupting once. His name was Nathaniel Cross. When I finished, he asked exactly one question. "Did your father ever believe records could be destroyed?" I thought about the duplicate ledgers, the locked metal case in his office, the way Dad used to say that the truth should never depend on a single copy of anything. "No," I said. Nathaniel tapped the unsigned petition sitting between us. "Good. Then your brother has made the mistake of assuming he's the only one who prepared for a war. He told me, right from the start, to forget everything Derek had ever said about love, loyalty, or fairness. We're not going to prove you're the better child," he said. "We're going to prove what actually happened." For 6 weeks, we rebuilt the final 3 years of my parents' lives, one transaction at a time. I handed over bank records showing I'd personally transferred $198,000 from my own accounts into their medical care, their mortgage, their taxes, and emergency home repairs. I found calendar entries documenting hospital appointments, invoices signed by home health nurses, work emails time-stamped 3 in the morning from my mother's bedside. What we couldn't find turned out to matter just as much. Several months of statements had vanished from the trust's online portal. The administrator login had been changed exactly 2 days after our mother's funeral. A line of credit for $360,000 had been opened against the house without my knowledge, even though the trust explicitly prohibited any new debt without written approval from both parents. The authorization on file carried our father's signature. I stared at it until the shape of the life finally became obvious. The first letter of his name leaned backward. Dad never wrote it that way. Not once, not ever. Nathaniel sent it straight to a forensic document examiner and told me not to confront Derek under any circumstances. That restraint got much harder to maintain once the case reached discovery. Derek produced photographs of me entering the house, grocery receipts charged to our parents' card, and a spreadsheet titled Claire, Personal Benefits. He'd listed food, gasoline, utilities, and caregiver reimbursements as though every single meal I'd cooked for our parents had been a luxury purchase for myself. He even itemized the cost of a hospital parking pass. The grand total came to $591,000, almost exactly the amount he was accusing me of stealing. But when Nathaniel examined the underlying file, he found hidden columns. Derek had folded in the mortgage principal, our mother's treatment expenses, and repairs to the house itself, then quietly relabeled them as payments made for me instead of by me. He had turned the money I'd spent saving our parents' home into evidence that I'd exploited them. That was the version of me Derek carried into court, an unmarried, unsuccessful daughter who'd attached herself to aging parents because she couldn't support herself any other way. On the first day of testimony, his attorney displayed a photograph of my old apartment, nearly empty except for a desk, a folding chair, and 2 moving boxes. Derek told the jury it proved I had no stable life of my own. I remembered exactly when that photograph had been taken. I'd moved most of my furniture into my parents' house because our father could no longer manage the stairs alone. The folding chair was where I took client calls between medication alarms. Derek knew that. He'd taken the photo himself. The same afternoon, he helped me carry a lamp down to my car. She built a narrative of devotion, he testified. But devotion was her business model. The words cut deeper than I expected. Not because I believed them, but because I recognized our entire childhood inside them. Whenever Derek won something, our parents celebrated his talent. Whenever I simply endured something, everyone praised my patience instead. He was allowed to become impressive. I was expected to become useful. Then his attorney projected the final trust amendment onto the courtroom screen. Derek claimed our father had signed it while cognitively impaired, and that I had arranged the witnesses myself. In reality, the amendment named me successor trustee, required an independent audit before any distribution could occur, and suspended a beneficiary's rights entirely if fraud, coercion, or theft against the trust was ever proven. It didn't give me $1 more money. It gave me more responsibility, and it placed Derek's own access under permanent review. That was exactly why he needed it destroyed. During cross-examination, Nathaniel approached him holding a single hospital visitation log. You testified that you visited your father every single day during the month this amendment was signed. Correct? Derek said yes. Nathaniel then displayed travel records showing Derek had spent 19 of those 30 days at a resort in Arizona. Derek claimed he'd managed our father's care by phone instead. Nathaniel produced the phone records, 2 calls, totaling 11 minutes combined, for the entire month. Derek shifted in his chair. My sister controlled access. Then why, Nathaniel asked, did you email her asking what room your father was even in? The silence that followed felt completely different from the silence at the start of the trial. It was no longer the jury waiting to judge me. It was the entire room beginning to measure him instead. Derek recovered just enough to attack again. He claimed our father's federal career had made him paranoid, that the audit requirement was proof of his declining judgment, and that I had personally encouraged those fears for my own benefit. Dad trusted systems more than people, he said, almost smiling. Claire used that weakness. Nathaniel returned to our table and rested one hand on the sealed envelope beside his notes. No, he said quietly, just loud enough for me to hear. Your father trusted systems because he understood people. The envelope hadn't appeared on our public exhibit list because it had been held under a protective order while the court determined whether any federal information inside it remained restricted. Our father had delivered it to a retired military notary 9 months before his death. The notary placed it in tamper-evident custody, signed across the seal with 2 witnesses present, and transferred it to a secure records facility named directly in the trust documents. Nathaniel had only learned of its existence from a single sentence buried in the metadata of our father's final accounting file, integrity packet released only upon formal allegation of incapacity, coercion, or beneficiary fraud. Derek's lawsuit had triggered all 3 conditions at once. Before trial, the Department of Defense confirmed the packet contained no current classified material, but asked the judge to review the first section privately, since it authenticated our father's former position and referenced an old Inspector General investigation. That was why the envelope looked so official. It wasn't a secret government order, and it gave our father no power over the court whatsoever. It was simply the last chain of custody system built by a man who had spent his entire career expecting dishonest people to eventually attack the record. When Nathaniel placed it on the bench, the judge cut through the seal and unfolded the first page. The juror who'd risen to his feet had served as an Army logistics officer. He recognized our father's full title beneath the Pentagon letterhead, Walter Whitmore, former Deputy Director for Procurement Integrity. Years earlier, Dad had led an audit that exposed defective vehicle armor before it was deployed, including to a unit connected to that very juror's command. The juror later explained he'd never met our father and hadn't recognized my surname during jury selection. Seeing the title had simply startled him, and standing had been an instinctive gesture of respect. The judge removed the jury, questioned him under oath, and excused him to protect the fairness of the trial. An alternate took his seat. Derek's attorney demanded a mistrial. The judge denied it, after confirming no other juror had seen the page clearly or heard anything beyond the title itself. The moment was dramatic. But what actually mattered came after the courtroom doors closed. The first section of the packet contained 3 independent cognitive evaluations, all performed during the exact month Derek claimed our father lacked capacity. Each one found him alert, oriented, and fully capable of understanding complex financial decisions. One had been required before Dad could complete a consulting review for a federal contractor. He'd scored higher on the reasoning assessment than most active professionals half his age. The second section held a video deposition, recorded under oath with 2 attorneys present, neither of whom represented me. On screen, our father looked thinner than I remembered, but his voice was precise and unhurried. He identified every trust asset, explained the purpose of the amendment, and described the fraudulent line of credit opened against the house. "I did not authorize that debt," he said. "The signature is an imitation. I believe my son created it, or caused it to be created." My breath caught on the word son. I had known Dad was suspicious. I hadn't known he'd already reached that conclusion. The video continued. He described how Derek had pressured him to sell the house, argued that our mother's care cost too much, and asked for early access to shares in the family company. Then our father turned directly toward the camera. "My daughter has paid expenses that should have been paid by this trust. She declined reimbursement because she was afraid accepting it would be used against her later. I instructed my accountant to record every contribution as a debt owed to her, not a gift from her, and not income to her." Nathaniel paused the video and introduced a certified ledger included in the packet. It matched my transfers down to the cent. The $591,000 Derek had labeled personal benefits were, in reality, medical bills, secured debt payments, property taxes, and emergency repairs. Our father had annotated each entry himself, in his own handwriting. Beside the hospital parking pass, he'd written, "Claire stayed overnight again. She refused to let her mother wake up alone." I lowered my eyes. That one sentence nearly broke the composure I'd held through every accusation before it. Derek's attorney objected to the handwritten notes as hearsay, and the judge limited how they could be used, but the financial records themselves were fully authenticated regardless. Then Nathaniel revealed the packet's largest surprise. Our father hadn't merely documented my support. He had personally ordered an outside forensic audit of the trust, the company, and the home equity line. That audit identified transfers routed through a consulting company registered to Derek's own business partner, totaling $421,000. Derek had spent the entire trial accusing me of stealing $580,000 while quietly hiding nearly $500,000 he had diverted himself. The judge looked directly at him and warned that any further testimony could now be referred for a perjury investigation. For the first time in my life, my brother didn't answer immediately. His lips parted, but no confident sentence came out. The forensic audit gave Nathaniel permission to follow accounts Derek had spent months insisting didn't exist. The next morning, a court-appointed specialist testified that the home equity proceeds had moved through 3 separate entities before landing in a company Derek personally controlled. Some of the money paid off his business debts. Another portion funded a deposit on a condominium. $30,000 went to a public relations firm, 2 weeks before he ever filed suit against me. That firm had prepared talking points describing me as financially dependent, socially isolated, and positioned to exploit vulnerable parents. Derek hadn't lashed out with cruel opinions in a moment of anger. He had purchased them deliberately as a strategy. Nathaniel displayed the invoice, then asked Derek whether he had sent the trust petition directly to my clients. Derek claimed he'd only answered questions after the filing became public. Nathaniel produced an email sent before the clerk had even stamped the case. Subject line: background on Claire Whitmore before Monday's fraud action. Attached was the unsigned petition, along with the public relations talking points. One recipient was the reporter, who later published the article. Another was a client whose contract represented nearly a third of my annual income. You circulated these allegations before they were even filed. Correct? Nathaniel asked. Derek stared at the screen. My counsel handled communications. His attorney shot up so fast his chair struck the railing behind him. Privilege. The judge instructed Derek to answer only what he personally knew. He admitted to approving the email but insisted he genuinely believed every allegation was true. That was when Nathaniel opened an email archive recovered from our family's former financial advisor, a man I'd first met years earlier as someone our parents trusted to explain investments without making them feel foolish. In the weeks after our mother's death, he'd simply stopped returning my calls. Under subpoena, he admitted Derek had promised him a position managing the trust if I were removed. The emails between them were blunt. In one, Derek had written, "Once she's classified as a dependent, every payment looks like theft." In another, he'd instructed the advisor to delete our father's notes from the online ledger and replace the phrase, "amount owed to Claire," with "benefit paid for Claire." The advisor had replied, "This crosses a line." Derek answered, "The winner decides where the line was." The jury saw the dates, the server headers, and the backup logs proving none of it had been fabricated. Derek tried claiming someone had accessed his account without permission. The specialist showed every email had been sent from his own office network, on a device registered to him, confirmed by biometric login. He tried once more, insisting the advisor had simply misunderstood sarcasm. Nathaniel read the next message aloud. "Sell the house as soon as Dad is gone. Keep Claire occupied defending herself. By the time she clears her name, the property will belong to the development group." There was no gasp in the courtroom. No whisper. The cruelty was too organized for spectacle. I remembered Derek at our father's funeral, one hand resting on my shoulder while he told relatives we'd honor Dad's wishes together. That same afternoon, according to the timestamp, he'd emailed a developer photographs of the house and asked how quickly an occupant could be removed after a trust dispute. I had been the occupant. He'd planned my eviction while accepting condolences right beside me. To obtain the fraudulent line of credit, Derek had submitted a copy of our father's retired federal identification along with a letter falsely claiming the debt supported an approved consulting project. The lender's automated system flagged the application as connected to federal contract work and granted expedited review. Our father discovered the misuse when a verification notice reached his old Pentagon office. He reported it to the Department of Defense Office of Inspector General, which preserved the application and sent a certified copy directly into the integrity packet. That was the exact page Derek had believed destroyed. It was also why his whisper at the bench had mattered so much. Nathaniel asked him how he'd even known the file had existed in the first place. Derek's face tightened. "Dad told me. Your father's recorded statement says he never confronted you because investigators advised him not to," Nathaniel said. "Then how did you know?" Derek glanced toward his attorney, who was staring down at the table. The answer that finally came out was smaller than any voice I'd ever heard from my brother before. "I found a notice." "Where?" "In Dad's office." "The office you testified you never entered without permission." Derek didn't respond. The judge ordered him to answer anyway. He finally admitted that after our mother's funeral, he'd searched the locked cabinet and removed several files. He claimed he'd only destroyed duplicates because he feared grief had made our father irrational. Nathaniel held up the trust binder recovered from Derek during discovery. A cut edge inside the back cover matched the missing notice exactly. My brother hadn't stumbled into this lawsuit by accident. He had spent more than a year erasing evidence, rewriting ledgers, purchasing a public narrative, and using the courtroom itself as the final stage of the theft. The judge ordered the clerk to transmit the relevant exhibits to state prosecutors and the federal inspector general. Derek's attorney requested a recess. Before he left the room, Derek turned and mouthed at me, "You did this." I met his eyes and shook my head. I had spent years protecting him from the consequences of who he actually was. All I had done now was simply stop. When Nathaniel told me I could testify, I expected to feel relief. Instead, I felt the old instinct to minimize everything, to say the money didn't matter, that the insults hadn't wounded me, that I'd helped our parents because anyone would have done the same. That would have been just another lie, built purely to keep Derek comfortable. I took the oath and looked directly at the jury. I explained how I'd moved into the house after our mother's diagnosis, reduced my consulting work, and used my own savings when insurance delays threatened her treatment. I described the night our father discovered the forged line of credit, sitting at the kitchen table with a magnifying glass over the signature. I taught both of you that a name is a promise, he'd told me. I never taught your brother what happens when he breaks one. I had urged him to confront Derek directly. He refused. He said an accusation without proof would only teach a dishonest person exactly where the evidence was weak. At the time, I thought he was being cold. I understood now that he'd already begun building the packet. Derek's attorney tried to portray my care as control. He asked why I'd attended medical appointments, kept copies of passwords, and lived in the house. Because my mother couldn't stand without help and my father couldn't safely drive, I said. The person questioning my motives right now was usually somewhere else. He asked if I'd expected to inherit the house. No. I expected my parents to live long enough to use it. He asked if I hated my brother. I looked at Derek before answering. I hated what he did for years. I kept confusing that with a duty to protect him. Nathaniel then asked the judge to admit the final section of the envelope, a joint statement signed by both parents before our mother's last hospitalization, witnessed by independent counsel and recorded on video. My mother spoke first, her voice weak but unmistakably impatient. She said they had watched Derek turn every act of care into a competition and every asset into proof of his own importance. They had also watched me apologize for needing nothing. We failed both of our children in different ways, she said. We praised one for being visible and the other for disappearing. Our father then explained the trust's integrity clause in his own words. It didn't punish a beneficiary for raising a good faith concern. It applied only if a court found that a beneficiary had forged documents, converted assets, knowingly made false claims to seize control, or destroyed trust records. If proven, that beneficiary forfeited management rights and all discretionary distributions. The forfeited portion would first restore stolen funds, reimburse the injured beneficiary, and cover legal costs. Whatever remained would fund a non-profit program for family caregivers and veterans facing medical debt. Derek had spent the trial insisting the clause was my invention. On the recording, our parents described it line by line. Then our father held up a sealed copy and said, "Derek, if you're seeing this, you were given every chance to stop before the truth became public." Derek lowered his head. My mother's final words were directed straight at me. "Claire, do not mistake forgiveness for continued access. You may release the anger without ever reopening the door." I pressed my lips together, but the tears came anyway, not because the statement handed me a victory, but because my mother had finally seen the pattern I'd spent my whole life pretending didn't exist. Nathaniel asked me one final question. "Why did you fight this case?" I could have said it was for the trust, the house, or my own reputation. Because he was using my silence as evidence that he was right, I answered. I needed the record to show that care isn't dependency, that restraint isn't weakness, and that being family doesn't give anyone permission to destroy you. As I walked back to my seat, I wonder how many times in my life I had called surrender peace, simply because conflict frightened me more than losing did. That question hurt more than any of Derek's accusations. It also, somehow, freed me from all of them. The jury deliberated for less than 4 hours. During that time, Derek approached me in the courthouse corridor while his attorney had stepped away to take a call. He didn't apologize. He said the family could still contain the damage if I agreed to a private settlement before the verdict came in. He'd withdraw his claim, let me stay in the house for 5 years, and stop contacting my clients. In exchange, I would ask the court to seal the exhibits and tell investigators our father had simply misunderstood the loan application. Even after every email, every forged record, and our parents' final recorded statement, Derek still believed consequences were something he got to negotiate. "You tried to make me homeless, unemployable, and publicly guilty," I said. Now you want privacy because the truth finally has your name on it. He called me vindictive. I told him I was done translating his fear into my guilt. Then I walked back into the courtroom without accepting a single word of his offer. The jury found Derek liable for fraud, conversion, intentional interference with my contracts, and defamation. They found his conduct had been deliberate and malicious. The judge separately ruled on the trust itself, removing him from every fiduciary role, enforcing the integrity clause in full, and ordering a complete accounting of every asset connected to him and his companies. Derek was ordered to repay $421,000 plus interest, reimburse my documented contributions and legal expenses, and surrender his beneficial interest pending final distribution under our parents' original instructions. The jury awarded compensatory damages for the income and reputation I'd lost, then added punitive damages substantial enough that Derek's attorney immediately asked for the amount to be reduced. The judge said post-trial motions could be filed, but the evidence, in her words, supported a severe sanction. By the end of the hearing, my brother faced a judgment exceeding $1 million, the total loss of his trust share, and separate state and federal investigations involving forgery, financial fraud, destruction of records, and misuse of federal identification. The financial advisor surrendered his license during the regulatory inquiry and later agreed to cooperate fully. The development company quietly withdrew from the house deal. The reporter who'd repeated Derek's allegations published a correction linking directly to the verdict. My former client sent a carefully worded apology and asked whether I'd consider returning. I declined. Some doors had closed because Derek pushed me through them, but I no longer wanted every room that had once accepted his version of me so easily. Derek's business partners removed him from management within a week of the verdict. A few relatives called me cruel for letting the case become public. None of them had called when my accounts were frozen, or when my name appeared beside the word fraud in a newspaper. I stopped defending myself to people who needed my suffering to stay quiet before they'd agree to call me kind. Months later, the court approved the final trust accounting. After debts, reimbursements, and legal obligations were settled, the portion Derek forfeited went toward funding the Eleanor and Walter Whitmore Caregiver Relief Initiative, providing emergency grants to adults caring for ill parents and to veterans' families facing medical debt. I kept the house, not as a trophy, but because our parents had explicitly given me the choice to live there or place it into the program instead. I converted our father's old office into a free records clinic where caregivers could organize insurance claims, powers of attorney, and household accounts before a crisis ever made them vulnerable the way I had been. The first time I unlocked that room on my own, I found a note taped beneath the bottom drawer, written in Dad's handwriting. A clean record cannot guarantee justice, but it gives justice somewhere to stand. I sat down on the floor and cried harder than I had at any point during the trial. Derek eventually sent me a 6-page letter. Most of it explained what pressure had done to him, how our parents had favored me near the end, and how humiliation had made him desperate. The final paragraph contained the only apology in the entire letter, followed immediately by a request that I tell prosecutors he had acted purely out of grief. I never answered. Forgiveness, I've learned, can be entirely private. Reconciliation requires truth, repair, and real change, and Derek was still searching for language that let his choices belong to someone else. On the anniversary of the verdict, I stood on the front steps of the house on Larkspur Street while families arrived for the initiative's very first workshop. I had won the case, but victory didn't feel like triumph over my brother. It felt like the end of my obligation to lose so that he could feel powerful. I thought I'd leave that courtroom feeling joyful. Instead, I felt grief, relief, and a quiet certainty that I had finally stopped abandoning myself. My brother had tried to use our parents' trust to erase me completely. The sealed envelope didn't hand me revenge by destroying him. It simply returned every choice to its rightful owner. His choices became his consequences. Mine became my future. As I closed the door that evening, I asked myself one last question. Was walking away an act of revenge? Or was it the first genuinely honest act of love I had ever shown myself? I already knew the answer.